Good morning. Can I help you today?
Yeah, I'm here to apply for a divorce. Do you have any information for me?
This is a scene repeated daily in courthouses. Perhaps you've asked the same question. The answer to, how do I get divorced, is not simple and straightforward. It's certainly not something court staff can explain to you at the counter. But they can give you forms, instructions, general information, and referrals to mediation and legal services. The rest is up to you.
This video explains how to start your divorce and includes tips from experienced family court judges. In Minnesota, a divorce is called a marriage dissolution. You can get forms and instructions for a dissolution from the court administrator's office. This video only covers how to start your dissolution. You must carefully read the instructions and follow through with all the requirements to obtain an order ending your marriage. Let's turn now to two questions that everyone asks. What will it cost to get a divorce? And how long will it take? You will pay a one-time court filing fee. If you truly can't afford the fee, ask the court administrator how to apply for a fee waiver, known as an IFP. After you fill out an application for the waiver, a judge will decide whether or not you have to pay the fee. The decision will be based on your income and other evidence of your ability to pay. How long a marriage dissolution takes depends on many factors. The simplest dissolution might take a few weeks. A complex dissolution might take more than a year. The quickest way to complete a marriage dissolution is to work cooperatively with your spouse and resolve all disputes about property and children before you start the dissolution.
I encourage people involved in a dissolution to resolve their differences outside of the courtroom. Going to trial and having the judge make the decisions can be costly and time-consuming. And at least one of the parties, or often both of the parties, will not like the result. However, I do not encourage spouses to meet and negotiate an agreement if there has been domestic abuse in the marriage. If you have been physically or mentally abused by your spouse, do not risk your safety or financial future by discussing disputed terms of your divorce directly with your spouse. Minnesota law says the court can never force you to mediate with your spouse if there is abuse.
Another common question people have is, can I handle my divorce without a lawyer? The answer is, you are not required to have a lawyer, but it is advantageous to have a lawyer.
Handling your own dissolution works best if you and your spouse agree on everything, or if your spouse never responds to your papers. If your spouse never responds, you may ask the court to grant a decree of dissolution based upon what you requested in your petition. If you can't resolve your differences and you have to go to trial, you are wise to get an attorney. Even if you anticipate no disputes with your spouse, you should get legal advice from an attorney if you have significant property or other circumstances involving complex legal issues. An accountant can advise you on the tax consequences of dividing your property and paying support. A child psychologist or a family counselor can assist you in making appropriate choices for the care of your children and well-being of your family.
Here is a list of the most common situations that complicate a marriage dissolution. Consulting an attorney is recommended in the following situations. You or your spouse have significant assets or debts, or you suspect your spouse is hiding assets. You or your spouse have a pension or profit-sharing plan. Either of you own real estate or a business. You or your spouse have filed or plan to file for bankruptcy, or are involved in a personal injury lawsuit. You or your spouse want or need spousal maintenance, short-term or long-term. You inherited significant property during the marriage, or owned significant property before the marriage. You or your spouse is serving in the military. You have children together. A child was born during the marriage to the wife, and the husband is or might not be the father. You and your spouse signed an anti-nuptial contract. You have immigration questions, or your spouse has an attorney. You can hire a lawyer to handle your entire case, or you can consult with a lawyer about specific questions but still represent yourself. If you are low income, free or low-fee legal help may be available. The ideal time to seek the advice of an attorney or other professional is before you start the paperwork or make any written agreements with your spouse. You should understand the law before making any decisions. Court staff and judges are not allowed to give you or your spouse legal advice. Only an attorney can do that. Once you understand the legal issues, it can be helpful to use a mediator to reach an agreement with your spouse. For some divorcing couples, anger, worry, stress, or a desire to get a quick divorce gets in the way of making reasonable decisions. A mediator can help make the discussions productive. A mediator is a neutral third party who helps you reach an agreement. Court staff can give you information about mediation services.
If you have decided to handle your dissolution yourself, you can select a forms and instructions packet from the court administrator's office. Several different divorce packets are available. To select the packet appropriate for you, you need to know that marriage dissolutions fall into two main categories: dissolution with children and dissolution without children.
If you and your spouse have minor children together, select the marriage dissolution with children packet. A minor child is under age 18. You must also use the dissolution with children packet in the following situations. You and your spouse have an 18-year-old child who is still attending high school. You and your spouse have an adult dependent and disabled child. Wife is currently pregnant or becomes pregnant before the divorce is finalized. Or wife has a child born during your marriage, but husband is not the father of the child.
Under Minnesota law, if a married woman becomes pregnant or has a child during the marriage, the woman's husband is presumed to be the father.
Here's an example to illustrate what the law means. John and Jane get married. After 2 years, they decide to separate. Jane moves out and begins a new relationship. She then has a baby fathered by her new partner. Because Jane and John are still legally married, John is the presumed father of the new baby. When they file for dissolution of their marriage, Jane and John must use the marriage dissolution with children packet. The forms and instructions explain how to ask the court to determine that John is not the father.
Failing to properly address the issue of paternity of a child has serious consequences, and there are strict time limits for asking a court to determine that the husband is not the biological father. If you have questions about this, please ask an attorney for advice.
Use the dissolution of marriage without children packet if you do not have minor children together, if the wife is not pregnant, and if no children were born to the wife during your marriage. No matter what forms you use, you will start by filling out the petition. In the petition, you answer questions about your marriage, your property, and your children. You also tell the court and your spouse what orders you would like the court to make.
The instructions in the packet will help you understand the purpose and meaning of each statement in the petition. The instructions are general and may not answer all of your questions. If you have additional questions, please ask an attorney for advice. Now, let's take a close look at the petition.
This is the petition. The top of page 1 is called the case caption. Every form you will use for your dissolution starts with the case caption. The case caption identifies the court, the names of the people getting divorced, the type of case, marriage dissolution, and the case number. The person filling out the petition is called the petitioner. If you are starting the divorce, write your name on the line for petitioner. Your spouse is the respondent, the person who will respond to your petition. Write your spouse's name on the line for respondent. Your case will be assigned a number by the court administrator's office at a later time. Once you have your case number, include it in all documents and correspondence. The petition is a fill-in-the-blank document. You should type your answers or print very neatly using dark ink. If your handwriting is not readable, the court will return your papers and you will have to start over with new forms. The petition has 2 sections. In the first section, you answer questions about your marriage and children and provide detailed information about property and debts. In the second section, you state what you want the outcome of the divorce to be. For example, if you and your spouse own a car, you will list the car in the first section of the petition, and in the second section, you will state who should get the car. Following the case caption on page 1 of the petition, you are asked to provide full names and addresses for you and your spouse. Every question on the petition is important, and you must make reasonable efforts to get the information. For example, if you do not know your spouse's zip code, look it up. Despite your best efforts, if you cannot obtain the required information, write unknown on the answer line. Never leave a question blank.
Hopefully, you know where to find your spouse. After you have completed the petition, you must have a third person hand-deliver a copy of the summons and petition to your spouse. This is called personal service. If your spouse's whereabouts are unknown to you, you will have to take additional steps to request a court order allowing you to serve your spouse some other way. This makes service more complicated. The instructions for service are in the packet.
After names and addresses, you will write down the date you were married, the date you separated, and whether you have lived in Minnesota for at least the last 6 months. If you have not lived in Minnesota for the last 6 months, you cannot start your divorce now. Wait until you have lived in Minnesota for the required 6-month period.
Some states don't allow you to file for divorce until you and your spouse have lived apart for a certain period of time. In Minnesota, you may file for dissolution even if you and your spouse are currently living together.
The next questions on the petition are about finances. To answer these questions, you will need to refer to your records, make phone calls, and possibly ask your spouse for information. For example, this question asks for the spouse's monthly gross income and deductions. To answer this question, you will need your spouse's pay stub, tax returns, or other records. If you are unable to get all of your spouse's income information, write in what you do know and answer the other questions unknown. For example, you might know your spouse's take-home pay, also called net pay, but not the gross pay and deductions.
If you and your spouse have been separated a long time and you are not in contact with your spouse, unknown may be the answer to several questions. For example, you won't know if your spouse is working, has insurance, or has purchased a different car. Don't guess on an answer. Do your best to obtain and record accurate and complete information, or write unknown.
Several of the questions on the petition relate to your property. You will be asked about household furnishings, cars, bank accounts, investments, businesses, pensions, and real estate. The idea is to fully disclose everything currently owned. It doesn't matter who bought the property, who uses the property, or whose name is on the title. List all the property you own, all property your spouse owns, all property you own together, and all property either of you own with a relative, friend, or business partner. A common mistake people make in filling out the petition is to omit property they or their spouse acquired before the marriage or after they separated. List all property currently owned, no matter when it was acquired. Here are some examples to further illustrate the important point that you must list all property currently owned by you or your spouse. You would include in the petition a condominium the husband buys in his name only after separating from the wife. You would also include stocks the husband owns that he purchased prior to the marriage. If the wife purchased a car during the marriage, in her name only, you would include it. If the wife owns a cabin with family members but her husband is not on the deed, include the cabin. If the wife has a checking account in her name only, include it in the petition. Just as you listed all your property, you will also list all debts. Debts are sums of money you owe and pay off over time. Debts are not routine bills you pay in full each month. List all debts in your name alone, your spouse's name alone, and in both your names. If the debt was incurred before your marriage or after the two of you separated, you still must list the debt in the petition. Sometimes people question the need to disclose their financial affairs in the petition, especially if they agree on how to divide everything and expect no disputes. They may look at the financial disclosure as an intrusion of privacy, or just a lot of unnecessary work.
Full financial disclosure is required in every marriage dissolution because a judge must decide if the decree of dissolution includes a fair and equitable division of the parties' marital and non-marital property. Marital property is all property acquired during the marriage, except for property acquired by inheritance or gift received by only one spouse. As a judge, one of my responsibilities is to review the petition and all agreements and determine if the proposed division of property and debt is fair and equitable. Without full knowledge of the financial circumstances of the parties, a judge can't decide what is fair and equitable.
What is a fair and equitable division of the marital property? There is no set formula or definition. It does not mean a strict 50-50 division. It depends on the circumstances of the parties. The petition and any written agreement you reach with your spouse must include a detailed division of all property. If your petition or written agreement divides the property so that one spouse receives significantly more property than the other spouse, you should explain in your petition or agreement why you think this division is fair and equitable.
I encourage you to make an agreement with your spouse regarding the division of your property. But if the proposed division of your property is not fair and equitable, or if you fail to include all property in the agreement, I will not grant your decree of dissolution of marriage. If your proposed division is lopsided, you would be wise to consult an attorney for advice before presenting the agreement to the judge.
In addition to questions about property, the petition asks you to identify your children and your spouse's children by name and age. If you and your spouse have minor children together, either biological or adopted, you will also answer questions about custody, parenting time, and child support.
In general, Minnesota law encourages both parents to actively participate in the lives of their children. The dissolution decree will grant custody of the children to one or both parents and will set a schedule for the time each parent is responsible for the care of the children. State law also requires that all dissolution decrees include orders for payment of child support, medical support, and child care reimbursement for the minor children of the parties. Child support is not a bargaining tool. A child has a right to child support, taking into consideration the standard of living the child would have enjoyed if the parents had remained married.
There are two types of custody, physical and legal. Physical custody means the routine daily care and control and residence of the child. The child lives with the parent who has physical custody. Physical custody is either sole or joint. Joint physical custody means that the routine daily care and control and residence of the child is structured between the parties. If the parents have joint physical custody, the child lives part of the time with each parent. Legal custody means the right to determine the child's upbringing, including education, health care, and religious training. Legal custody is sole or joint. Joint legal custody means that both parents have equal rights and responsibilities to participate in major decisions determining the child's upbringing. Parenting time is the time a parent spends with a child regardless of the custody designation. Your schedule for parenting time for both parents should be clear and specific. For example, instead of stating that the children will be with the mother every other weekend, it is helpful to define what you mean by weekend. Does the weekend start on Friday evening or Saturday morning? The mother will have the children every other weekend from Friday at 6 p.m. to Sunday at 6 p.m. is clear and specific. It is also helpful to state who will provide transportation for the parenting time. The petition also asks you to identify who will have parenting time on holidays. The form does not identify the holidays because what one person considers a holiday, another person does not. But the best way to handle holidays is to list each holiday that is important to you and to state the parenting time schedule for each specific holiday. If your schedule for parenting time is clear, you are less likely to have conflicts over parenting time in the future. The written instructions explain how to calculate child support. Read and follow the instructions carefully. Upon completion of the first section of the petition, you will move to the second section, where you tell the court and your spouse what you want. First, you want the court to dissolve the bonds of matrimony between you and your spouse. In other words, to end your marriage. In Minnesota, the court does not need proof of wrongdoing to grant a marriage dissolution. You simply state that your marriage is irretrievably broken. This means your marriage is over and you are unlikely to reconcile. The required language is included in the petition. You do not have to write it in. In the second section of the petition, you will also state whether or not you want spousal maintenance, formally called alimony. For all the property you listed in the petition, you will state who should get the property. For each debt, you state who should be responsible for paying the debt. If children are involved, you will include your custody, support, and parenting time preferences, which must be based on what is in the best interests of your children. When you have completed both sections of the petition, read the verification before you sign the petition. The court can order you to pay money to the other party if you have made false or misleading statements in your petition. If you have any questions about your rights or what is likely to happen, ask for legal advice before you sign the petition. Keep in mind that the forms provided by the court are general forms. You may need other language to address your needs. A lawyer can help you revise the petition to meet your needs. To complete the petition, you must sign it in front of a notary public or a deputy court administrator. The notary will require picture identification. If you and your spouse are in agreement on all issues and you are using a joint petition, you will both sign the petition in front of a notary. With a joint petition, both husband and wife are petitioners, and both verify that all the information in the petition is truthful. When you complete any document for your dissolution, make a copy of it for your personal records. If you and your spouse are filing a joint petition, the rest of this video does not apply to you. If you have a joint petition, please refer to your written instructions for further information. After the petition is complete, your next step is filling out the paper called summons. Write your name and your spouse's name at the top of the summons. If either of you own real estate, include the legal description of the real estate in the summons. The legal description can be found on the deed or mortgage for the property. The legal description is not the street address. The summons tells your spouse that you are asking for a divorce. Your spouse has 30 days to serve you with a written answer if he or she disagrees with your petition. In the answer, your spouse must state which paragraphs in your petition are true and false. The answer may include a counterpetition where your spouse states what he or she wants. The summons also includes restraining orders that apply to both you and your spouse. You should read and follow the restraining orders.